Hello everyone, welcome to Synthesis IAS Academy, a place where blend of ideas takes place. About me, I am Sandeep Bhushan and my credentials are I have 10 years of teaching experience for civil services and I take up issue-based current affairs. And this session will certainly help you to crack prelims and mains examination because throughout my session I would be emphasizing on the importance of keywords and key phrases, so that the keyword and the key phrases which I would be emphasizing will definitely make you get into the mode of identifying the factual, analytical and conceptual questions for the preliminary examinations, and also it will be very useful for you in regards to the mains, that is for the answer writing. So definitely your answer writings would be precise and concise as per the demand by the UPSC, because you will be in a position to inculcate the keywords and the key phrases in your answer writing for the mains. Thereby, my session will guide you to crack both prelims and mains for both 2020 as well as 2021. And the topic for the day is Insolvency and Bankruptcy Code Bill 2020. And before we get into the topic, that is the Insolvency and Bankruptcy Code 2020, we will definitely focus at the subtopics. The main topic is Insolvency and Bankruptcy Code Bill 2020, but we will definitely look at the subtopics. And the importance of the subtopics is because you will have a thorough and a comprehensive understanding about the Insolvency and the Bankruptcy Code Bill 2020, wherein that is necessary for the UPSC perspective. So the top subtopics are the Sikh Industrial Companies Act 1985, Sikh Industrial Companies Special Provisions Act 2003, Insolvency and Bankruptcy Code 2016, and within that you have the Corporate Insolvency Resolution Process, part of the Insolvency and Bankruptcy Code 2016, and the other one is Insolvency and Bankruptcy Code Second Amendment Bill 2019, and part of this Bill 2019 you have the Financial Service Providers Rule 2019, and the last is Insolvency and Bankruptcy Code Bill 2020. So before we actually get into the entire understanding of what is the bill about the Insolvency and Bankruptcy Code Bill 2020, it is necessary, it is evident that to all the civil servant aspirants, you need to know the background, and we will try to get into the mode of definitely understanding right from 1985 and then 2003, 2016, 2019 and now 2020. So now we will get into the topic. The main subtopic is Sikh Industrial Companies Act 1985. So what was going on in India around 1980s was India has witnessed a rampant industrial sickness, and when India has experienced a rampant industrial sickness, it is the need, or it was the need for the government of India to come up with the legislation to make sure that the sick or the industrial sickness should be protected, and thereby the government of India has come up with the legislation called as the Sikh Industrial Companies Act. And the necessity for the Sikh Industrial Companies Act was to combat the issue. Which issue are we talking about? The industrial sickness. So the government has come up with the Sikh Industrial Companies Act 1985, and this is or was an Indian law to make sure that it detects the Sikh companies, so that the Sikh companies are the one which are really not performing, they will not pose a systemic financial risk to the entire industrial economy itself. So thereby the Sikh Industrial Companies Act of 1985 has come into existence to make sure that the Sikh companies will not pose a systematic financial risk to the industrial economy, or thereby to the entire economy of the nation. And this act has come into being so that they can spot the sick or the potential sick companies. The act can spot or will spot the sick and potentially sick companies, so that the sick companies can be spotted and we can take a speedy measures to overcome the sickness of the companies. First is to make sure that they revive it, or if there is a situation that there is no need to revive, or in case if there is no provision to revive this sickness or to come up with the remedial measures to overcome the sickness of the companies, so what is the next measure is to close such units. So thereby there is a, if there is a possibility, it will be revived, and if there is no possibility to revive, they have to be closed. They have to be closed, so that there should not be any kind of systematic financial risk to be taken. And in turn, it was repealed. That is SICA, that is Sikh Industrial Companies Act, was repealed and replaced by another act in the year 2003, that is called as Sikh Industrial Companies Special Provision Act 2003. Because of few of the dilution existing with the Sikh Industrial Companies Act 1985, there was a necessity to come up with or repealing the existing SICA Act 1985, and it was replaced by Sikh Industrial Companies Special Provision Act 2003. That means in the year 2003, for the Sikh Industrial Companies Special Provision Act, there were few provisions which were included. So this, what provisions were included apart from 1985 to the Act of 2003 SIC is, we will focus. The main change or the changes to the new law was to make sure that they were trying to combat the occupational diseases. So definitely the workers or the companies can go ahead with having a kind of combating the occupational diseases. How? So they were going ahead with using the medical certificate, which they have used it to protect their companies, but in turn they were actually the sick companies which were growing. And this Sikh Industrial Companies Special Provision Act 2003 aimed at reducing the growing incidents, because there was a high number of incidents which were prevailing, which were taken up by the companies, that they were using the medical certificates to evade legal obligations. So these medical certificates were used by the companies to evade, to overcome the legal obligations and access concessional granted to the financial institutions. So the companies, few of the companies were using the medical certificates to evade legal obligations and to have concessional grants from the financial institutions. So thereby the main intention was to overcome this. And later on we have seen even the Special Provision Act of SIC 2003 has also been fully repealed in the year 2016, because few of the provisions of the SICA Special Provisions Act 2003 were being overlapped with one of the act that is called as the Companies Act 2013. So as it was overlapping, the provisions of 2003 Act was overlapping with the Companies Act 2013, so it was repealed. It was repealed and a new code has come into the existence, and that is called Insolvency and Bankruptcy Code, and it was notified on 28th May 2016, and it has come into existence on December 1st 2016. So we have seen 1985 and then 285 and then 2003, and now we have the 2006 Insolvency Bankruptcy Code. So it is very important that before you understand the emergence of Insolvency and Bankruptcy Code 2016, it is always good to have the information or the background information about the SIC Act 1985 and SIC Act of 2003. Now we will focus at the Insolvency and Bankruptcy Code 2016. So this code 2016 IBC has provided a time bound process. Why? Because definitely, as there were a situation that the insolvency was taking place because of the creditors or debts, both the sides, from the creditors and the debtor. That means who give loans and who takes loans, who the one who gives loan and the one who takes loan. So there is, or there was a situation that both the sides, because of the debts and the creditors who were unable to collect the money in regards from the defaulters or the one or the NPAs, non-performing assets. So they were very clear that they wanted to have a time-bound process, which was certainly provided in the Insolvency and the Bankruptcy Code 2016 to resolve the insolvency. That means wherein you are totally bankrupt. You do not have any money to repay the loan. So in that scenario, in that situation, the IBC 2016 provides a time bound process to resolve the insolvency between the creditors and debts. So this is a default, and whenever a default in repayment occurs, so when you are supposed to repay a loan and you are a defaulter, in that scenario the creditors can gain control over debts. That means here in this case, the banks who are giving or who are providing loans to the MSMEs or to small companies, they can take control over the debtor assets. Please do understand here. So the Insolvency and the Bankruptcy Code 2016 gives the control to the creditors, to the debts assetors, to the debtors assets, so that they can resolve the insolvency and they can make sure that they can go ahead with selling the assets and then they can repay the loan. And under this IBC, debtor and creditors both can go ahead with initiating recovery proceedings against each other. Please do understand, it is not compulsory that creditors are gaining control over debts or debtors, the one who are purchased, who have taken the loans. But here both the debtor and the creditor can start the recovery proceedings against each other. And this IBC Code 2016 has been implemented through an Act of Parliament, and it has got an assent on the month May 2016. And this law was necessitated, it was required because there were huge pile up of non-performing loans of banks. That is, NPAs have increased, non-performing assets have increased, and because of the non-performing loans of banks, and there was delay in the debt resolution. So definitely, as we said, that it is a time bound process and to resolve the insolvency, but because of the pile up of non-performing loans of banks, there was debt resolution which was delayed, thereby the resolution has come into existence. And before that, we will look at the insolvency resolutions in India. That means to resolve any kind of insolvency in India, it takes 4.3 years. But if we compare with the another countries, that is UK, it takes only 1 year. And in regards to the USA, the resolution, insolvency resolution, takes only 1.5 years. So there was a need that there has to be a speedy resolution mechanism to be into existence, so that the creditor and debtor will not be hooked up in a process or a dispute. So this applies both for companies and for partnerships and individuals. Partnerships and individuals. The IBC applies to various companies or partnership or even individuals. And this IBC code 2016 also provides for a time bound, as we discussed, so that it would be resolving any kind of insolvency between the creditor and the debtor. And when a default take place in regards to the repayment, so here the creditors, as we discussed again, it will take control over debtor assets, and it can make or it must take any decision in regards to the resolving the insolvency. And here the companies have the complete to enter the insolvency within 180 days. So whenever a company is not paying or they are unable to pay the loans, so they have or they can enter into insolvency, that is to resolve the insolvency within 180 days under IBC, and the deadline may be extended if the creditor do not raise any objection. That is, here in this case, if the creditor is bank and the bank is not raising any objection, then it can be extended, but it has to be resolved within 180 days. This is the keyword, that the resolving the insolvency should be initiated within 180 days. And because of the resolution, now we will focus at a resolution process called as corporate insolvency resolution process, that is CIRP. So CIRP shall be completed within 180 days. 180 days, and if they wanted to have any kind of further extension, it has to be, the extension can be taken up only with the consent of NCLT, only with the consent of NCLT under corporate insolvency resolution process between creditor and debt and the one who had taken the loan, with the consent of the National Companies Law Tribunal, and that too it can be extended to a maximum of 270 days from the date of insolvency or the commencement of the date of the insolvency. And this will be even applicable to smaller companies or any startups which their turnover is rupees 1 crore, wherein the entire exercise of the insolvency must be completed in 90 days. We discussed that it should be a period of 180 days, or further it can be extended with the consent of NCLT to the maximum of 270. But if it is smaller companies or startups, the insolvency must be completed within 90 days, and it can be further extended. The deadline can be extended for another 45 days. And this, if you look at within the CIRP, there is a regulatory board, that is within the corporate insolvency resolution process. Please do look at, this is a keyword here which you need to focus for UPSC prelims perspective. And there is another keyword which will be acting as a regulator, that is Insolvency and Bankruptcy Board of India. Please do understand here, Insolvency and Bankruptcy Board of India has been appointed as a regulator. So this is acting as a regulator in all the above proceedings between the, that is in regards to the insolvency resolution between the creditor and the debtor. And this Insolvency and Bankruptcy Board of India has 10 members. This is again very crucial information for preliminary examination. Has 10 members from the Finance Ministry, Law Ministry, and from the Reserve Bank of India. And this Insolvency and Bankruptcy Board of India is acting as a regulator in regards to the insolvency resolution proceedings. And this board regulates insolvency professionals, insolvency professional agencies, and information utilities also. So it regulates all the proceedings in regards to the insolvency professionals, insolvency professional agencies, and information utilities which are set up under the IPC code. And these proceedings of the resolution process will be adjudicated, will be as per the NCLT. All the resolution process of the proceedings will be under the judiciary and will be adjudicated by the NCLT, that is National Companies Law Tribunal, and the Debt Recovery Tribunal. So all the resolution process proceedings will be under the judiciary of the NCLT and DRT. But what is the key that you need to focus is, the NCLT will be focusing the resolution process proceedings for companies, or the resolution process, insolvency resolution process between the companies or in regards to companies and the creditors will be resolved by the NCLT, and the resolution insolvency process will be looked at or adjudicated by the Debt Recovery Tribunal TRD for individuals. So there is a difference, please do understand. For individuals it is by DRT, for companies it is for NCLT. This is the key. You need to have the understanding of difference. And the public announcement in the entire resolution process proceedings should be made in the newspaper. So there has to be a public announcement being made in the newspaper, wherein by announcing it in the newspaper, by public announcement, you are inviting any claims from the creditors or from the corporate debtor, so that they can come up with their claims. And once these claims are being put forward, they would be collating the claims, verifying the claims of both the creditors and debtors, and you will have the interim resolution professional. You will have, once the claims are being accepted, collected and verified, the interim resolution professional shall continue a committee of creditors. So once the claims are collected and verified, you will have a committee called as committee of creditors, and this committee of creditors will take decisions regarding the insolvency resolution. So please do understand the importance of various keywords we are trying to focus, which will be very useful for UPSC prelims perspective. And now we will look at the Insolvency and Bankruptcy Code Second Amendment Bill 2019. So we are focused at 1985 till now, and then 2003, and then 2016, now 2019. So this is the chronology which has to be in your mind, so that you will have a thorough and a comprehensive understanding about the Insolvency and Bankruptcy Code Bill 2020. And this bill of 2009, IBC Bill 2009, it aims to remove various difficulties which are being part of the insolvency resolution process. So it is trying to remove the difficulties from the insolvency resolution process, so that the objective of the IBC Code 2019 will be realized, will be focused, will be attained. And the other one is ease of doing business. This is a keyword. This is a keyword for prelims as well as mains examination. So IBC Second Amendment Bill 2019 realizes the objectives of the code, that is Insolvency and Bankruptcy Code, and it will realize the ease of doing business, wherein the government of India is focusing on it. And this bill seeks to amend various sections of the IBC Bill 2016 of 5 of 12, 5 of 15, section 7, 11, 14, 16, 1, 21 of 2, 23 of 1, 29A, 227, 239, 240. And not only just amending this section, they have inserted a new section in the IBC Bill 2019, that is section 32A was inserted in the Insolvency and Bankruptcy Code 2016, so that it will be part of the IBC Second Amendment Bill 2019. And IBC Bill 2019 provides a timely conclusion of cases. This is very important. They wanted to conclude the cases, not trying to drag it or not trying to make sure that it is having a lengthier time. And then it will have a greater flexibility for both the corporate restructuring for maximum value of assets. So definitely it will be a greater flexibility for restructuring, corporate restructuring. Why? So that once you restructure, you will have the maximum value of the assets. Restructuring, that means you are making sure that it is kind of you're making it delay it, or you're giving some time, you're bargaining some time. And the other one is protecting primacy of the creditors, and then also remove various or removing voting deadlock. So you have the various deadlock in the voting of the home buyers. So all these are being taken care by the IBC Bill 2019. And for within this Bill 2019, you have rules also. You have rules in regards to the Financial Service Providers Rule. Please do understand, this is another keyword. So within the IBC Bill 2019, to make sure that the entire process or in the bill or in regards to the insolvency resolution process should be taken up in a speedy process. So there is a rules for that. The entire insolvency and liquidation proceedings. And you have a rule called as Financial Service Providers Rules 2019, and this is also crucial and we will look at it. And these were issued on 15th November 2019. Why? Because it provides a framework. The Financial Service Providers Rules 2019, which was issued in the year 2019 on 15th November, it provides a framework for what? For insolvency and liquidation. Please do understand, it is not for insolvency resolution process. It is not for insolvency resolution process. It is for insolvency and liquidation proceedings. That means when the creditors have control over debtors assets, those assets, how they can be liquidated, and once those assets are liquidated, that amount which has been liquidated through the assets can be again used as part of the loan to be credited into the creditor or the banks. So here the financial service provider rules are for the framework for insolvency and liquidation procedures, and this is for financial service providers other than banks. So please understand, here the banks do not get into the Financial Service Providers Rules 2019. For the Financial Service Providers Rule 2019, it is other than banks. It is other than the banks. That is, it is for financial service providers. It could be microfinancial institutions, it could be micro, small and medium enterprises, it could be non-banking financial companies. So various others financial service providers will be in a position to take up or use or to have the framework called as Financial Service Providers Rule 2019. So do have the difference of the understanding between the insolvency resolution process under Bill IBC Bill 2019 and the Financial Service Providers Rules 2019, wherein it provides a framework for insolvency and liquidation proceedings for financial service providers other than banks. And now we will look at what this rules, Finance Services Providers Rules 2019, actually takes up. So these rules can be applied to FSPs, providers, or any categories of financial service providers which are certainly notified by the central government under Section 227. And this is crucial information again for preliminary and a better conceptual understanding for mains examination. So Financial Service Providers Rules 2019 can be applied to FSPs and various other categories of FSPs which are notified under central government, under again by the central government under Section 227, and this can be done from time to time, that too with the consultation with appropriate regulators. That means they can come up with the Financial Service Providers Rule. And what is the purpose of it? So this will act as a making sure that it will be used for the insolvency and liquidation proceedings as we discussed. But all this will be which have been notified by the central government under Section 227, and these rules aims to serve as a interim mechanism. Please do understand, this is a keyword again. So this rules, Financial Service Providers Rules, acts as an interim mechanism in dealing any kind of exigency pending introduction, wherein it will be dealing again with the financial resolution of banks or any other systematically important service providers. So it is basically to make sure that it will be working as an interim mechanism to deal any exigency pending issues or pending regulations or proceedings, and it also provides resolutions for individuals under insolvency and bankruptcy code. So financial service providers rules are not only for the financial service providers or categories of FSPs which are notified by the central government under Section 227, but it can also provide resolution for individuals Under what? Under Insolvency and Bankruptcy Code. And these rules provide for the process and forms of making applications so that it can initiate any kind of insolvency resolution and banking proceedings against personal guarantor, even to the personal guarantor. Please do understand, it is not only to the debtors but also who have guaranteed the person who have taken the or accepted or they have attained the loan, and it will be for the withdrawal of any kind of such applications also. And now we will focus at what is the latest one, that is the parliament has passed Insolvency and Bankruptcy Code Bill 2020. And what does, we have seen on September 21 2020 Lok Sabha has passed the Insolvency and Bankruptcy Code Second Amendment Bill 2019, and now it will be that once it is passed, it is Insolvency and Bankruptcy Code Bill 2020. And what does this provide? It provides the insolvency proceedings. It provides various changes or amendments to the insolvency proceedings against the defaulters, who later on these defaulters would be gradually getting into the mode of a non-performing asset category. And now these defaulting companies wherein the insolvency proceedings now cannot be taken up by the creditors and will not be initiated for at least 6 months starting from March 25, and it would end by 24th September 2020, that is today as on date. Why? Because they have extended this for another 6 months because of the COVID-19 pandemic situation. And wherein you have the entire damage to the economic activity. Because of the damage to the economic activity, the insolvency proceedings cannot be initiated for at least 6 months, right from March 25th 2020 till 24th of September 2020. And once they have passed this Insolvency and Bankruptcy Code Bill 2020, Finance Minister Nirmala Sitharaman has said this is not just a recovery bill. It is not just a recovery bill, because the creditors like MSMEs or NBFCs, MFIs and various others, it could be again in regards to the corporate banks also, they have several options to recover the claims. So it is not just a recovery law, but it is apart from that, it says. And now this bill or the bill code bill 2020, it replaces the previous ordinance which was taken up on June 5th, and now it suspended the previous or the ordinance, which was again the companies or the stressed companies which have been part of the stress or non-performing assets or defaulters because of the COVID-19 situation. And this recovery rate, if you look at, because of the IBC, Insolvency Bankruptcy Code, the recovery rate is 42.5%, and the recovery done by Lok Adalat is 5.3%, and the recovery done by Debt Recovery Tribunal is 3.5%, and the recovery by SARFAESI Act is 14.5%. What is SARFAESI? SARFAESI, again this is important for preliminary examination point of view, because SARFAESI is Securitization and Reconstruction of Financial Assets and Enforcement of Securities Interest Act 2002. So the highest recovery is through IBC. So thereby the IBC of 2016 which was passed, and now definitely it is yielding result. And the main objective of the IBC is to make sure that ease of doing business for the foreign investors to go ahead with doing business in India would be a platform wherein they would be really wanting to come to India and invest in India, so that the foreign investors or FDIs and FPIs would be increasing. Not only that, it also provides greater transparency. So this is the keyword, ease of doing business, and then greater transparency is another keyword which is pertaining to the IBC code. and also to enhance the efficiency of the Companies Act 2013. And if you look at the ranking in regards to the World Bank's doing business 2020 report, India has moved up to 14th position to 63rd position, from 67th to 63rd. This is in regards to the ease of doing business. It is in regards to the ease of doing business. It has attained 63rd position. And you have another report which is in regards to the another index. This is in regards to the resolving insolvency index. Again, these are very important. Both of them are very important for preliminary perspective UPSC. So ease of doing business 63rd position. Resolving insolvency index, India has jumped. In the year 2018 it was 108, but now in the 2019 it is 52nd. So definitely it has jumped 56 places, and this is a crucial information. And I hope the entire session was informative, knowledgeable from UPSC perspective for both prelims and mains examination. And I hope this session will make you feel that you are having a thorough and comprehensive understanding of the Insolvency Bankruptcy Code 2020, and it will certainly make you have an edge over others. And I would say a very big thank you, and then good luck to you all. And then before you sign off, do like the video, share the video, and subscribe the Synthesis IAS Academy YouTube channel, wherein you can definitely have the blend of ideas taking place. And I would come up with the next topic, which would be a current issue based topic, which will certainly be useful for you for UPSC prelims and mains perspective. Thank you very much.